Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Today, a change in the courts with major implications for health. I speak to Judge David Tatel, who recently took senior status on the U.S. Court of Appeals for the D.C. Circuit after joining the court in 1994. He was appointed to fill the seat created by the appointment of Justice Ruth Bader Ginsburg to the Supreme Court. Previously, he worked as a civil rights lawyer inside and outside of the federal government. Our conversation focuses on a recent Supreme Court case with big implications for health agencies. Let's listen. Judge Tatel, I am thrilled for you to be here with me on Public Health on Call. I'd love for you to start by introducing yourself a little bit to our audience.
Yes, and thank you, Josh, for inviting me. My name is David Tatel, and I am a judge on the United States Court of Appeals for the District of Columbia Circuit. I've served on that court now for almost 30 years. And for the previous 30 years, that is after I graduated from law school, I practiced law mostly as a civil rights and education lawyer.
Now, if I'm not mistaken, the court that you serve on is often involved in cases that involve health agencies that are implementing policies, and those policies may be challenged for one reason or another.
Yes, that's exactly right. The U.S. Court of Appeals for the D.C. Circuit obviously sits in the District of Columbia, and it in effect presides over the federal government. And it hears cases from most all federal agencies, including the ones that are most responsible for promoting public health, like the Food and Drug Administration, U.S. Department of Health and Human Services, Environmental Protection Agency.
Got it. Now, I know we're going to talk about some recent developments with the Supreme Court, but I want to start with just the usual previously customary approach that the court would take. Say the Food and Drug Administration or the EPA goes out and does something and there's a lawsuit. What are you thinking, as you are starting to read that?
Yes, we have the courts over the years have developed a fairly consistent set of principles for reviewing challenged agency action. So, for example, suppose an agency issues a regulation requiring certain types of health precautions to be taken. The first thing we do is to look at the statute under which the agency issued that regulation. Federal agencies only the authority that Congress has given them. So we start by looking at the plain language of the statute. And if the statute is clear, then that controls the case. If the statute clearly gives the agency the authority, then that's the result we reach. If the statute clearly denies the agency the authority, then we vacate the action the agency taken. Most of the time, though, statutes are not that clear. Statutory language is ambiguous. It's ambiguous for lots of different reasons. When it is ambiguous, the question we ask, that is that the courts ask, is did the agency act reasonably? If it acted reasonably, then we don't second guess their judgment. This is called Chevron analysis. It flows from a case decided by the Supreme Court called Chevron versus the Environmental Protection Agency. And it directs courts to review agency action by first looking at the language of the statute. If that's clear, quote, that ends the analysis, which is what the court said. And if it's ambiguous, the question is whether it's reasonable. That's called Chevron analysis, and that's what we've been doing for decades.
And, that is consistent with how I thought about the role of the courts when I worked at the Food and Drug Administration. If there was a new problem that we were trying to address, we asked ourselves, well, do we have the authority and the laws that authorize the agency from Congress to take action? And, do we go about it reasonably? Are we listening to people? Are we taking public comment? Are we thinking through the right things? And we absolutely were sued from time to time. And we were hoping that there'd be judges on the other side who would look at this and say what the agency did makes sense to them.
Well, it wasn't just that it makes sense. I mentioned ambiguity. Ambiguity is the key concept here because the courts interpret ambiguous language as a congressional delegation to the agency, which, if you think about it, makes a lot of sense, Josh. Congress wants to promote public health or safety in a particular field. It doesn't have the expertise to do that. So it enacts legislation authorizing the agency to take that action and directs it in what area to function. And so it essentially delegates to the expert agency the job of fashioning regulations to accomplish that particular health objective. So general language in a statute is viewed as a delegation. And the question we answer is, you said, does it make sense? Well, I'm not sure that's the right way to put it. The question we ask is it reasonable? And in those cases, the parties debate that question. The agency explains to us why it thinks it is reasonable. The party challenging it argues that it's not reasonable. And if we think it's reasonable, that ends the analysis. And this is very important because it means that if it is reasonable, we will enforce the agency action, even if we don't necessarily agree. This is a way of ensuring that expert decisions are made by agencies, not by judges.
That makes sense. And of course, I absolutely accept your reasonability test rather than the does it make sense test, no question. Just to give an example here, if the law says that the Food and Drug Administration has the responsibility for food safety, then the agency itself, the Food and Drug Administration, may issue a regulation that determines how food manufacturers get inspected. How frequently, for example, that could be a topic. If companies say, well, hold on a second, are you allowed to do that? That kind of thing would be subject to this reasonable test you're talking about.
Yes. And the way that would come out until recently would be the party challenging would say, well, I don't see anything in the statute that says you can require food inspections. And the agency would say, well, yes, it's not there, but it does charge us with promoting food safety. And we can't promote food safety without requiring inspections. And what the reviewing court would most likely say is, well, that certainly sounds reasonable. We can't imagine how Congress's objective could be accomplished unless the agency were able to do inspections. And therefore, that regulation is valid.
Now, you used two words there that I think have a lot of us in public health pretty nervous. And those words were until recently. So why don't you explain what's happened recently?
Well, in the past several years, the Supreme Court has been in the process of questioning, and maybe we're still completely unsure about this, abandoning the Chevron approach. That is the approach where we look first to the language and then to whether or not the agency's action is reasonable. And in a series of decisions culminating last June in a case called West Virginia versus the Environmental Protection Agency, the court articulated a new standard. In this case, an EPA regulation, coal-fired power plants was at issue. The challengers argued that it exceeded EPA's authority because instead of simply regulating the emissions from a particular power plant, it required all power plants that provide electricity to the grid to, over a period of time, shift their fuels from coal to natural gas to renewables. In other words, this regulation was designed to shift the nation's electrical grid from fossil fuels to renewables over a 20 or 30-year period. Now, normally, the way we would have looked at that, and in fact, the way my court looked at it, was they looked at the Clean Air Act, and which provided the agency authority to promote clean air and a health and safety environment, and concluded that this regulation was reasonable. Well, the court rejected that and developed a new standard. It never mentioned Chevron, and instead it said that where in a case like this one, there was a regulation that had major economic and political implications for the country, which this case obviously did. It regulated the entire electrical grid of the country. In a case like that, that's considered a major question. The agency can only act if it's expressly authorized to do so in the statute.
So let me make sure I'm getting this. Typically, you would look at a regulation from the EPA for regulating coal-fired plants by asking whether the law for the EPA gives enough room for the EPA to act and whether the EPA is being reasonable. But now the Supreme Court says, wait a minute, it's not whether or not there's enough room, it's whether Congress actually specifically said that this action can be taken by the agency.
That's exactly right, Josh. So in this case, for example, what the Supreme Court said was missing in the statute was an express authorization to the EPA to promote generation shifting. That is, to promote, to encourage or require the electrical grid to move from fossil to natural to renewable. They said that's not in the statute, and therefore the agency doesn't have the authority.
So what is the logic of this perspective that the Supreme Court is now bringing, that we want Congress to be making these kinds of decisions? Would that be the best argument that they would have?
Yes. The court is, I would say, skeptical about administrative agencies. Some of the justices have said so expressly. They think that administrative agencies are, yes, they're appointed by the president and confirmed by the Senate, but in some agencies, they can only be removed for cause. And the court is concerned that administrative agencies are adopting rules and standards that are unreviewable. And this is a way of reining them in and requiring that Congress legislate far more specifically than it has in the past.
You use the phrase reining them in. I think that people in public health are worried that it's more like cutting them off at the knees, that public health agencies have responsibilities under the law, including to tackle new challenges that have arisen. But if all these major topics require Congress to sit down and write a law about it, then the agency is kind of powerless. Do you think that's a paranoid reading?
No, I don't think it's paranoid at all. And many people, many commentators, both lawyers and non-lawyers, are deeply worried about the implications of this for the promotion of public health and safety, because up until now, Congress has delegated this authority to expert agencies. And what the Supreme Court is now saying is that Congress really can't do that unless it expressly authorizes the agency to take a specific action. And of course, the question is, well, does Congress have the expertise to do that? Worse yet, the ability to do it. You know, Congress uses general language to authorize an agency to do things for a couple of reasons. One reason it does it is that it really does want to delegate the responsibility to an expert agency and leave it the flexibility to address the problem nationally. But it also uses general language because members of Congress can't agree among themselves on what specific action should be taken. At what level should promotion standards be set? What specific kind of agency should be authorized? They can't agree on the specifics, but they can agree on the overall goal, the promotion of public health and safety. So they delegate that to the agency. And now, as a result of West Virginia and other recent cases, there's some serious question now as to whether and how Congress can do that.
In a way, asking an expert agency to think through an issue and put in place standards or rules to address it, including for unknown issues at the time, it is a form of compromise in Congress. But the Supreme Court has kind of suggested it might be taking that away, and that could lead to gridlock rather than Congress actually stepping in and coming up with an approach.
Yes, it could mean, exactly. With a divided Congress, it's quite unlikely that, at least for many of these issues, Congress will be able to act. That could have very severe consequences for our country.
Now, I've been to some meetings where people can list a lot of topics that this could apply to. The Food and Drug Administration, the EPA, the CDC, multiple agencies suddenly no longer able to do the kinds of things that they've done for many years. And frankly, that I've always thought that Congress expected them to do. But we don't know for sure how broadly this doctrine will be applied.
Correct. And that's the way the courts function. So the court has, in this case, adopted what's called, quote, the major questions doctrine. And now in future cases, it will tell us more and more what that means. In my court, we are already getting cases where organizations or individuals are challenging agency action on the grounds that it raises a major question and the agency lacks the authority to take the action. And my court will decide these cases, and then those decisions will be reviewed by the Supreme Court. And over the next few years, hopefully the court will tell us in more detail exactly what major question means. It will tell us whether this is, as many are concerned, a broad limitation of federal agency action across the board, or whether it is perhaps truly limited to situations as major as that was at issue in the West Virginia case. We just don't know yet.
I can imagine that people who don't like what agencies might do, companies, for example, that may be losing money as a result of a regulation that is intended to improve health, now have another argument to make. Instead of just saying it's not reasonable, which they could have argued before, they now can say, hold on a second, I don't see that in the law explicitly. And it's not enough that the Congress gave the general area of oversight to an agency. They need to really be specific, and we don't really see it here, and it should be struck down for that reason.
Yes. I mean, that is what my court is going to be spending a huge amount of time on in the next few years, because, as I said, these cases are already appearing in court.
I think that a lot of people in the public health field, read about the Supreme Court, read about court decisions, but don't necessarily engage directly. Sometimes, maybe some of us will sign on to briefs, for example. We're talking about a pretty major shift here. What do you think people in the field of public health who want to preserve the ability for agencies to take actions that could save many, many lives? What can we do? What's the best way to engage with the legal system or the political system?
Let me start by saying you are absolutely right, Josh. This is a very, very big deal. It's called the Major Questions Doctrine. It's a major development and has enormous significance for the ability of all federal agencies, including those that are responsible for public health and safety. Huge consequences for it. I think the single most important thing that the community can do, that is institutions and individuals who are interested in preserving our nation's ability to protect the public health, is to make sure in the cases that do reach the courts, my court first and then the Supreme Court, that the courts understand, even though it's a major question. It's going to be hard to argue on the major question aspect of it, although they should be arguing that some of these regulations are not effective, which leaves, we think, standard Chevron analysis there. But they should also be making clear to the courts what the consequences are of ruling that the agencies don't have the authority that Congress has plainly given them. I honestly don't know what else can be done other than to make sure that the court is itself fully educated and fully apprised of the consequences of its decisions.
Judge Tatel, thank you so much for coming to the podcast. This has been a really informative and certainly sobering discussion, but it really is important, I think, for people to understand this major change and the implications that it could have.
Yes, thank you for inviting me, Josh.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, and Stephanie Desmond. Audio production by J.B. Arbogast, Holly Cardinale, Philip Porter, Spencer Greer, and Matthew Martin, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media run by Grace Fernandez and Shian Briscoe. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.